Ecoa is a federal law enforced by the Consumer Financial Protection Bureau. Ecoa stands for Equal Credit Opportunity Act and primarily deals with a credit application. Now, Ecoa is also known as Regulation B. And I remember that Ecoa is Regulation B because the purpose of Ecoa is that it enforces creditors to be equal when granting credit. Now, Ecoa prohibits discrimination on 8 different protected classes, and they are as follows: race, color, religion, national origin, sex, age, and marital status, in addition to the receipt of income from public assistance. If a borrower wants to file a discrimination complaint, it's Ecoa that states that they have the right to do so. And Ecoa also prohibits a lender from discouraging an applicant from applying for a mortgage or reject their application because of their race, color, religion, national origin, sex, marital status, age, or if they receive public assistance. Now keep in mind, let's say that you collect the 6 pieces of information you need to submit an application on a borrower's behalf. But as you're looking at the information they provided, you can't help but notice that they are not going to be approved. But even though you know that they're not going to be approved, you cannot discourage the borrower from applying. You don't make the final decision, the lender does. So they should complete the application, submit it, and wait for what the lender is going to say. So a question on the exam may say, it is a violation of blank to discourage a borrower from applying for a mortgage. And the answer would be Ecoa. It is a violation of Ecoa to discourage a borrower from applying for a mortgage. Now, one area that people really struggle with on the protected classes is the one that is about age. Now, it's important that we clarify that when it comes to age, a person must be of legal age to enter a contract in the state that they reside in or are trying to get a loan in. Ecoa states that a borrower is entitled to receive a copy of the appraisal report at least 3 business days before the loan closes. So, upon receipt of an application, lenders have 3 days to notify a borrower of their right to receive a copy of any appraisal. It's because of Ecoa that a lender may only ask a borrower if they are married, unmarried, or separated. These are the only choices on the loan application. In the same way, a lender may not ask a family about how many children they have, what their birth control practices are, what their intentions are for how many children they're planning to have. Instead, Ecoa states that a lender must ask how many dependents the borrower has. Now, a dependent could be a child, but it's not limited to only a child. It could be a foster child, grandchild, niece, nephew, parent, grandparent, aunt, uncle, sibling, etc. A creditor may, however, ask about the ages of dependents or financial obligations related to the dependents, so long as it's done without any discrimination to any of those 8 protected classes that we talked about. Now, if a borrower receives alimony or child support, it's Ecoa that states that a lender may not discount this income if the borrower chooses to use it. However, a lender may not ask a borrower if they receive alimony or child support. Instead, they can ask, is there any other income you'd like to be considered on this loan application? Remember, Ecoa prevents discrimination on the source of a borrower's income. A creditor can discriminate against the amount of income. So, for example, A creditor can't discriminate if a borrower's income has come from being an adult entertainer. They can, however, discriminate that the amount that has been verified by being an adult entertainer doesn't meet the minimum threshold of what would be required for a loan. Now, if an applicant is denied for a loan, Ecoa states that the denial letter, known as a notice of adverse action, must be in writing. Now, in the same way that there are standards for what is given to a borrower at certain times, a lender must also adhere to certain timelines to respond to a borrower. So, for example, if a borrower submits a completed application, Ecoa states that a lender must provide an answer, whether that's an approval, a denial, or a need for additional information. They must do this 30 days after they receive an application from a borrower. Now, it's important that you understand that a letter of adverse action has 4 parts to it. The adverse action must contain a statement of action taken with the application, the contact information of the lender, the reasons for the decision, or a statement of the right to receive the reasons for the decision, and the name and address of the federal agency with jurisdiction. Keep in mind, an applicant can request a statement of reason for denial within 60 days of receiving the original adverse action notice. So just to recap, according to Ecoa, a lender must respond to an application within 30 days of receiving it. The answer the lender may give is approval, a letter of adverse action, also known as a denial, or a request for more information. If a lender gives a letter of adverse action, an applicant has 60 days from the date of receiving the notice of adverse action to request a statement of reasons for the denial. And further, Ecoa states that a lender must give notification to the applicant of action taken on the application of a counteroffer if the applicant does not express intent to proceed to accept the offer. Now, pivoting slightly here, if an application for credit is denied based on the appraisal, Ecoa says that a borrower has 90 days to request a copy of the appraisal, and the lender has 30 days to deliver it. Now, before we continue talking about Ecoa, it's important that we go over some important things regarding appraisals that are crucial for you to know for the SAFE exam. Property appraisers must be paid a flat fee that is not based on the appraised value of the home that they are reviewing. Property appraisers must be licensed and be held to the standards set forth by the Uniform Standards of Professional Appraisal Practices, otherwise known as USPAP. An appraisal is valid for 6 months. However, a recertification will be necessary if the appraisal will be 4 months old or more at the time of closing. Now, because Ecoa has to do with being equal on the premise of granting credit, it's important that you understand that a loan originator should avoid asking any questions that can be perceived as discriminatory. And in the same way, Ecoa also prohibits the use of overt discrimination, also known as explicit or obvious discrimination. And it also prohibits disparate treatment. Now, disparate treatment is the difference in how a member of a protected class is served or treated by an institution. So, an example of this could be charging a higher rate or charging more fees for members of a certain protected class more than a similarly situated member of a non-protected class. The Home Mortgage Disclosure Act, better known as HMDA or Regulation C, is a law that was implemented by the Federal Reserve Board that was introduced in response to lenders who were redlining. So through the implementation of HMDA, there are now measures put in place to determine the evidence of disparate treatment through statistical analysis, which is on Section 8 of the 1003 loan application. HMDA's purpose is to identify possible redlining, which you'll find more information on under the Fair Housing Act module and the other federal laws module. To ensure that no discriminatory practices are taking place, Ecoa states that when a lender does an application face-to-face, the interviewer must disclose the applicant's race, ethnicity, and sex based on visual observation, or surname, which is also the last name of your applicant. The visual observation or surname would be disclosed on the bottom of the 1003 loan application. And lastly, in regards to Ecoa, it's important that you remember that a consumer can sue for a violation of Ecoa for 24 months. Therefore, Ecoa records must be kept for 25 months. The Civil Rights Act of 1866 was a law that was passed to prohibit the public and private racial discrimination in any property transaction. It was later amended and was called the Civil Rights Act of 1968, but is now commonly referred to as the Fair Housing Act. The biggest thing you need to remember about the Fair Housing Act is that it has to do with discrimination in the sale and lease of residential property. Similar to Ecoa, the Fair Housing Act has 7 protected classes. The first 5, sex, race, religion, color, national origin, you should recognize because they are the exact same as Ecoa. The 2 additional protected classes, however, that are different from Ecoa are presented in the Fair Housing Act as disability and familial status. So, what are the 7 protected classes of the Fair Housing Act? Sex, race, religion, color, national origin, disability, and familial status.